shouldn't have been a messin', and now someone else is getting all your best.
Hello, ladies and gentlemen. My name is Mark DiCarlo. This is Voices of the Coastal Bend, and today is July 24th, 2010, and my guest is Anna Jimenez, who's the District Attorney in Nueces County. Hello.
Hi, how are you?
Thank you for coming on. You were appointed as the District Attorney by Governor Perry, is that right?
That is correct, in March.
And I had asked you before the show, how is it that one could be politically lined up enough to get an appointment from the governor of the state of Texas? How would how does that work?
I don't necessarily know that I was politically lined up enough because I've never done anything in politics whatsoever. I can explain the process to you. Basically,
what was the process? How did you find out that, about the appointment and the government would do it, et cetera? The governor would do it, et cetera.
When Carlos announced that he was going to be retiring his position as district attorney.
That was Carlos Valdez, the former district attorney.
Yes. There was information that basically the governor was going to have the power to appoint a district attorney to carry out his unexpired term, which would be up until November. There was an application process, and I looked on the website. Initially, it wasn't something that I thought I would attempt because I didn't think that that was something that was reachable for someone like me who just has been a public servant working in the DA's office doing their job. But as I started to hear some of the people that might be trying, I thought, you know what, if those people are qualified enough to run the district attorney's office, I think I'm qualified enough to do the same. So I spoke to a few people about it because actually I was approached to consider applying. And after I tossed it around and prayed about it a little bit, I sent my application. Several people applied and they interviewed everyone. The governor's office interviewed everyone.
Democrats and Republicans?
Democrats and Republicans. There were several people, all local people that applied for the position. And, when I went up there to the Capitol to do my interview, I thought, wow, this is such a great experience. Even if I do not get the appointment, just to have come through this process is really, really great. But I went up there, and a couple of weeks later, I was called and notified that I was actually the one that had been selected to fill this position.
And did you meet Governor Perry?
I did not. I met his committee person. I'd met the governor before at functions, but I did not meet him during my interview
They say he's got
process.
a great hairdo.
He does. He does have a great hairdo.
That's good.
And he's smart, so that helps.
And the so did you have a formal interview with a panel of people? I'm sorry.
It was the chairman of the appointment committee that I met with.
Could you share for us any questions he might have asked you?
Basically, he asked about my experience. Of course, I supplied a resume. I supplied a few letters of recommendation. He asked what it was that I had done in the DA's office, what I had done as a private practice attorney, my ties to the community, whether or not I had family here. He asked me basically what I thought set me apart from the other people that were applying for the position. And questions like that. It was pretty informal compared to what I had expected.
What did you tell him were your qualifications regarding experience that would entitle you to be, that would make you a good district attorney in Nueces County? Do you remember?
I basically told him that I'd been practicing since 2000, and I'd done every kind of criminal and family law and a little bit of personal injury, a little bit of wills and probate in my private practice. That I'd been practicing.
You did criminal defense too, quite a bit, didn't you?
I did criminal defense and family law. That
never
was
thought you would
my
have.
Practice.
Never thought that you would have gone turncoat out.
Well, let me tell you, I have to.
I never thought that would happen. I'm just kidding.
As my brother said, the dark side. That I came to the dark side when I went to the DA's office because he's a defense attorney.
Yes.
But, basically, in doing that job, I needed to do something more. I felt compelled to do something more. It wasn't fulfilling enough. And I had taught before.
I'm hurt. No, I'm just teasing.
For me, it wasn't fulfilling enough for me. I taught before, and I wanted to make a difference in the community. And, teaching was fantastic, but even then I knew I had to do something else, which is why I went to law school. So I told him basically that I had this experience doing the defense work and doing criminal law and family law, but because I needed something else, I ended up going to the DA's office, and I was hired into a child abuse unit, which was a specialized unit in the DA's office, handling felonies, the minute you walk in the door, basically. I had the benefit of being able to try other types of cases other than child abuse while I was there in the DA's office. Either a prosecutor was going to be out of town or they needed some assistance on a different type of trial. So I actually was able to try capital murders, aggravated assaults, family violence cases. So I've been able to try almost every kind of criminal case there at the DA's office. And I told him, you know, I know exactly what the office is like, how it's run, how the administration works, what we're lacking, what's done well, and I explained those things to him.
How does a child sexual abuse office work in Oasis in under the district attorney? How does it work? There's like 4 people, there's like 2 people. Why is it separate? Why is it a separate office apart from the rest of the DA's office?
There are only 2 attorneys assigned to that unit. We probably could use 4, you know, because it's a tremendous caseload. Each attorney handles 4 district courts, probably about 275 cases each, depending on how the month is going and the intake is going in that particular area of the office. The office is separated and we're placed down the hall from the DA's office, and we were fortunate enough to get a grant, and some students from Miller came over and painted the walls in there so that we would have a more kid-friendly environment. It's specialized because the victims are special. They're usually young kids, and the court process is very intimidating to them. So we try to make it as comfortable as it can possibly be, knowing that you're going to have to put a 6 or 7-year-old kid in front of a jury of strangers and have them tell about horrible details that have happened to them. So that's one of the main reasons that it's a specialized unit, and it also takes somebody who can deal with those cases every single day because they're a little stressful, and so we want prosecutors in there who want to do that kind of work.
What are the percentage of those cases that go to trial?
Oh gosh.
Is it more or less than regular case? Is it more or less than regular criminal cases?
It's probably more
because
than
the plea bargains are pretty harsh, right?
The plea bargains are pretty harsh, and now since 2007 and that the law has changed, they're not eligible for probation from a jury on many of those sexual assault cases. So it really depends. If we have a victim that can go through it, and sometimes the victims just need to go through the trial process to face their attacker and say, you know what, I'm not afraid anymore. We end up in trial on those cases pretty often. And it's hard to compare to the other caseload because there's a tremendous caseload in general at the DA's office. So there's somebody in trial every single week somewhere.
You mentioned about the fact that these children have to testify oftentimes at these trials. Whatever happened to the capability to videotape them and have them testify via like video in another room?
Well,
did you ever try it?
I've never done it. I've seen it done one time. It was not very effective. And the hurdle for us to be able to do that is enormous. We have to be able to show that the child would suffer, you know,
almost psychological problems or something.
Yes, and that they're under tremendous psychological stress. We have to get doctors to come in and testify. It's a big hurdle for us to do that. The problem with doing that too is that it's less personal for the jury. They don't get to see what the child is actually experiencing because the video quality has never been good.
So it could reduce the chances of conviction because it's less personalized?
Yes, it could.
I see. Now you said you have a tremendous caseload over at the Nueces County District Attorney's Office, right?
We do.
Why do you say that? How many cases? Do you have a number?
I can tell you what we've processed in the last 4 months since I've been there. We had a backlog of cases before I actually took this position, in probably about 400 to 500 misdemeanor cases that we were behind that had never even been opened or put into the system or assigned to court. And so we've worked on eliminating that entire backlog, and we did that in about 3 months. But what that means is that in the last 4 months, we've processed about 3,500 misdemeanor cases. And that's just misdemeanor. On the felony side, a misdemeanor case is something that would be a DWI or a theft that is not of a significant amount of money, a criminal trespass.
How many county courts prosecute misdemeanor cases?
4 courts.
Is the juvenile prosecutor's office under you as well?
It is. It's in a different location, but it is under the DA's office. It's under me.
And have you made any changes in the district attorney's office regarding misdemeanors and or prosecution of felonies and or the juvenile juvenile prosecution since you've been in office?
What we have done in terms of juvenile prosecution is that we have issued a policy regarding those violent offenses, even for juveniles. And that is that we ask for detention and we ask for something other than probation, some sort of a boot camp or commitment or something to that nature.
For juvenile offenses?
For violent juvenile offenses.
I see. And that policy wasn't in place before?
No.
And what's your rationale for doing that?
Well, because some of these juvenile offenders are actually becoming involved in gangs much earlier. We've had situations in the last couple of months where there was actually gang initiation and the juvenile just went and shot somebody for the purpose of a gang initiation and killed him. And those kinds of things and that total disregard for human life makes it very dangerous for us to have a juvenile on the streets rather than put away somewhere where he learns not to have that type of behavior.
We hear this phrase all the time, a gang. He's a gang member. What's a gang member? What are the names of the gangs? How can you prove that they're a member of a gang?
They actually tell you sometimes that they are because they're proud of it. That's the problem. They're proud. This is something that is almost making them famous. So they tell you about it. They tell you that they're part of the suicidal barrio or that they're,
What's that one?
Suicidal barrio.
Okay. So suicidal barrio,
it's a street gang.
Is one street gang.
Yeah.
You know much about it?
I do not know all the ins and outs and what their principles are because I don't know that they necessarily have any. It's basically a group of people that get together and say they're part of this gang and deal with the drug issues and miniature turf wars and things of that nature, go and tag up places with their signs on there and things of that nature. But the street gangs are becoming more and more violent. And obviously when you start learning bad criminal behavior as a teenager and it's not corrected, you're going to end up doing that as an adult too. And if you end up in prison, then you end up in one of those bigger prison gangs.
Do you think the criminal justice system is going to be able to help these kids stay out of gangs? Or is there other, whatever, sociological forces, divorce, etc., that are really not in your hands, right?
There's a lot that is not in their hands, which is why at the juvenile level, I think it's important that we try to do something more than put them on probation. If we get them into the youth boot camp and teach them, some sort of discipline and teach them that education is important, that's going to be more beneficial than putting them on probation so they can hook up with the same delinquents they've been hanging out with to learn more delinquent behavior rather than trying to learn to be good and productive adults.
But they learn a lot of deviant behavior or criminal behavior if they're incarcerated also, right?
And
TYC or
TYC
prison?
it's not the best place for them, which is
Yes.
not by any means what I would recommend for every single juvenile. I think that each juvenile should be given an opportunity to do something better. I just don't necessarily think that each of them should be allowed to be on the streets until they've exhibited an ability to do things better.
Where's Texas Youth TYC stands for Texas Youth Commission. That's where juveniles are incarcerated, right?
That's when they have been adjudicated and sent to TYC. Usually they go through a long process before they're actually sent there.
So after they've either been, the charges against them have been found to be true and or they've pled true to these criminal charges, if they're heinous enough or if they've been getting in trouble enough, then they might go to Texas Youth Commission for how long? Indefinite period of time, till they're 18, till they're 21? How does that work?
It just depends on the seriousness of the offense and what the commitment time frame has been given by the judge or whoever it is that hears the case.
Okay, so there is a commitment time frame sometimes. So that office, so what do? You drive over there once a week, once a month, and you say, oh, what's going on over here? Juvenile crime division. How do you administer something that's in a totally separate building and all?
We actually have, my first assistant, Jim Lawrence, goes over there periodically. We have constant communication with them on a daily basis. When they need something because something special has come down the pike, they either come over or have us go over and do whatever it is that needs to be addressed. For the most part, fortunately, some of these crimes that we've been getting are just your routine kid learning how to smoke marijuana for the first time and they got caught with it, or kid assaulting somebody at school, or those types of behaviors, some graffiti cases that end up being the routine type of offense for a juvenile. But when they're more serious in nature, of course, we're more hands-on.
Have you ever had to certify attempted to certify a juvenile as an adult because the crime they've committed is very severe, and you've gone through that process since you've been the DA in Nueces County?
The shooting that I talked to you about was the one that we attempted to certify.
Okay. And were you successful in certifying the
not.
person as an adult? So what are the what do you have to prove to certify a juvenile, which is a person under 17 for the criminal justice system, right? Person under 17 as an adult in order to try them as an adult? How do you do it? What is the procedure?
Basically, the procedure is that they will have a psychological examination performed on the juvenile. You will look at the seriousness of the crime. It has to be a serious offense. And then basically whether or not they understood the ramifications of their actions. And even if all of those criteria are met, it's still up to the judge to decide whether or not they can be tried in the adult court.
It's what's called, I guess, legally it might be called discretion, and unless it's an maybe abusive discretion, you can't appeal it. Is that right?
Exactly. There's nothing we can do about it.
So in that particular case, you did not appeal the judge's decision.
No.
Did the judge in that particular case state why they did not feel why the juvenile should be certified, or they just didn't state the reason?
He may have, but because I was not present, I don't want to quote what Judge Shamsi said as to his rationale for not certifying.
So would it be up to the juvenile court judge to decide whether or not the case should be certified? Is that right?
That's right.
And Judge Shamsi is I think he was appointed too, wasn't he?
He was appointed by the commissioners, actually, after Judge Carl Lewis passed.
And I think he's up for election also.
Yes.
Your office was kind of marked by some amount of controversy. Where your opponent is Mark Skirka, who Mr. Skirka was just on the show, and it should be run also. Again, ladies and gentlemen, this is the District Attorney Anna Jimenez, who's running against Mark Skirka for the DA's position. I guess that's in November of 2010. Did you fire Mark Skirka, and why did you fire him? What happened?
I actually did end up having to fire Mark Skirka. What happened was we had an office policy under Carlos Valdez that Carlos implemented in March of 2007, I believe. Maybe it was August. I don't know. It was after an election series. But Carlos implemented a policy that any assistant district attorney who was seeking office could not stay in the district attorney's office, that it was your automatic resignation by even announcing that you were going to run for a political office. When Carlos left, the afternoon that he left, he sent out a memo rescinding the policy, leaving it subject to the incoming DA's discretion. When I came in, the office had been operating on a series of memos. We didn't actually have a policy manual. So the first thing I did was put together a policy manual, and I re-implemented the policy about running. I changed the policy a little, though. It wasn't as strict as Carlos's policy that if you even say you're going to run for something, that's it. I actually loosened the criteria a little to say, upon filing in a partisan election, that is your resignation. This was a policy manual that was in place. Mark Skirka signed it. He understood it. And then when he had actually filed something, I didn't know he had filed it. It had been on file for over a month, which basically would have meant his resignation would have been a month earlier than that. So I gave him the opportunity to resign, but he did not.
Well, what Mr. Skirka had said on the air was that he felt because he was running in the Democratic primaries against these other Democrats that he actually wasn't running against you. If he would have lost that primary, then he wouldn't be running against you. So during that interim, he felt, I believe this is what he was stating, he felt that he should have been allowed to stay on because formally it wasn't an election until he was a candidate against you. Did you hear that argument? Or?
I didn't hear that argument. Basically, yes. The argument that I heard was that he wasn't the official candidate. But
yes, well,
in the policy manual, you don't have to be an official candidate. What the policy read, and he signed it, and I guess that meant he understood it, was any filing whatsoever that names one of the employees as a candidate in a partisan election is your automatic resignation. So there was a filing that he had made months earlier, I guess, for designating a campaign treasurer, naming himself as the candidate. That would have constituted his resignation. It's not, you know, we have a lot of work there. It's not something I go check regularly to see whether or not somebody has filed
Certainly.
something. I would expect people to adhere to the policy and tell me about it.
Well, I would have, let me ask you this though, and this is kind of an unfair public policy question. I might be able to help you with that. But how was anybody, you know, how long was, let's see, Carlos Valdez was the district attorney many years, correct?
About 18.
Okay, 18 years. Well, it's going to, your position is going to be secured if nobody could run against you in the DA's office, because they have to quit their job. The DA doesn't have to quit their job to run, but the assistant DA does have to quit to run. So your policy is going to be virtually, your candidacy, your continued position is going to be virtually assured, isn't it? If none of the assistants could run against you. Is that right?
Not necessarily, because there are other people in the community. We have assistants, because of the low pay in the DA's office, that end up quitting and going into private practice all the time, because it's really hard to sustain a family on, you know, some of the salaries that we have in place that we've not been able to change. And so it doesn't prevent people from running against the district attorney. It didn't prevent people from running against Carlos.
Carlos didn't have many candidates through the years.
Not many, but he did have candidates against him. Now, basically, the purpose of the policy, and I think it was Carlos's purpose too, was that when that policy was implemented by Carlos, he had had 2 ADAs who had been running for election, Mark Skirka and James Sells. Any type of political campaign is going to have some sort of chaos with it, some sort of a need to actually be doing your campaign rather than your work. It's going to cause disruption, especially if it's something that is within your office. And to have a candidate in your office running against the person who is holding the office, it's disruptive.
Well, I'm sure it would be.
Extremely.
How would you respond to the argument that, excuse me for interrupting you, how would you respond to the argument that, though, you know, this person should be able to take a leave of absence?
You know what, if the county would provide for that, it's not that big of, that wouldn't be an issue. But the county doesn't allow that type of long-term leave.
You mentioned that the salaries, and we'll come back to that issue maybe in a second regarding all this controversy, you know, during the time you've been district attorney. But let's talk about the low pay. You said that the DA's office is low paid. What is a district attorney? If I go over there right now and I want to apply as assistant district attorney, or I'm out of law school and I want to get a job as assistant district attorney, how much money do I make?
With benefits, $47,000.
$47,000.
With benefits.
And,
starting the level 27 is what the county calls it.
Okay, level 27 with benefits. Okay, what are the benefits?
You get health insurance. You get a small vehicle allowance, about $32 biweekly. Dental insurance, and retirement that is matched by the county, that is taken from your check.
Okay. So I don't, okay. And then what is the actual pay, do you know?
I think it comes out to
35 or so?
No, I think it comes out to maybe 42.
Okay, so 42,000. And you think that's pretty low?
I think it's pretty low for people who've just gotten out of law school, that have student loans, that have to
I understand
pay
the student
rent,
loans are real high.
you know,
right
and
now.
if they have children, it makes it very difficult.
Okay,
for
so
them.
let's say that. But you know, sometimes I wonder if people aren't misled regarding how well you're going to do in private practice, because of the. I was telling one of the prosecutors, as a matter of fact, I think it was Sandra Eastwood, before, you know, whatever happened there. We'll talk about that in a second. I said, well, so what's the big deal? If you're a district attorney, assistant DA, spend all the money you have, you know, because you have health insurance and all, and then you'll have a retirement account. So in a way, there's a certain amount of security and benefits, versus like someone like myself or something. You're running your own small business, and you have to provide for your own retirement account, which could be wiped out like that in the stock market or whatever. So let's talk about the retirement package. What do? Do you match the amount of money they put in, or is it a regular government or civil servant retirement package a assistant district attorney gets in Nueces County?
It's matched, but it, excuse me, it doesn't vest until the person has been there 8 years.
Okay, so is there a minimum, let's say I wanted to save all my money and I lived in an apartment with a mattress on the floor, and I saved nearly all my money. I saved $25,000 a year. Would you match it? Or is there a limit to the amount they'll match?
There's a percentage that they do take automatically, and I'm not
Okay.
sure what the percentage is. And you can contribute more if you'd like, but I don't think they match it all until you've vested.
Oh, I see. And then this is some sort of state employee retirement account or something?
No, it's county.
It's county. I see. I don't know how familiar you are with with the county and all that. So, and then let's say I'm there, okay, so I make it through my first year as assistant DA. How much money would I make the second year? The same? Is there cost of living adjustments? Is there seniority adjustments? Does it depend upon my actual position in the DA's office?
What happens is if the county gives a raise across the board, like a 5% increase for every employee, then that particular ADA or all of the ADAs would get that 5% increase. We go to the Commissioner's Court and we ask for everyone in the county is paid on a pay level, like a level 27 is the entry level for attorneys in our office.
Okay.
That level stays the same forever unless we can get the commissioners to approve more funds for the DA's office, or the commissioners approve a cost of living raise for the entire county and all of the employees. We ask every time that we be able to increase our pay levels for the entire office, but especially for the DAs, because in the surrounding counties with similar numbers, they get paid a lot more than we do here. Most of them start at about 56 starting levels.
You mean in places like Jim Wells and Claber County and these smaller towns, Sinton, San Patricio, they make more money than they do here?
They make a lot more money in the surrounding counties, but in counties with our similar size, similar demographics, they make probably starting at about $56,000.
Okay, so why, number one, why is that? And number two, are you going to change it? Or number three, you don't feel it's necessary to change it?
Of course I feel it's necessary, but we have to get the commissioners to agree that they will find the funds in the county to do that. The one thing that I am working on that I have control over is that we have a drug forfeiture fund. And that fund I can use to supplement salaries. So we are working on a way that I can do that internally without going to the county commissioners or the taxpayers to get increases that I know there aren't funds for.
Won't that give you an incentive to maybe get a lot of money from anything, rightly or wrongly, to help pay for your own salaries? You don't think it would work that way?
No, the law is very clear on the forfeitures and what we're allowed to seize and what we're allowed to do with it.
It is clear, but you know, it looks to me like if you're caught with almost any, they could take it, because even if you use it to transport drugs, I think, right?
Yes.
There could be a forfeiture. And if you started to change that, you know, if you change that, it would result in a lot of forfeiture of vehicles.
It's illegal activity. Anything you're using for illegal activity.
But it is true, in Nueces County, I have never seen a forfeiture for possession of personal amounts, but I think the statute would allow it. Is that right?
It would allow for it.
Would you plan to do that? That would be pretty drastic.
What you have to understand is that we don't get to go out and pick what we do. The law enforcement entities are the ones that actually forfeit. We do the court proceeding for it, and we get a percentage of that, a small percentage of what law enforcement would get from any benefit there. We can't go out and say, forfeit every single vehicle you have. It's what they forfeit in connection with the illegal activity, and they bring to us, and we process it.
And you're saying you couldn't exert any kind of political or social
I
pressure?
I could probably ask that they be more stringent on what they seize and what they forfeit. I haven't, but I could probably ask
let's
that they do
let's say that assistant district attorney starts at $42,000 a year out of law school, and let's assume that what's the highest an assistant district attorney could make, or not an assistant, but whatever your positions are, what's the first trial assistant? What's Mr. Lawrence's position, for example?
Well, I changed that when I went in because Mr. Lawrence took Mark Skirka's position, and
Right.
Mark Skirka was paid probably about around $12,000 more than Mr. Lawrence was paid. So I asked to reduce that job classification because the chief's salaries were very disproportionate to what the prosecutor's salaries were, and I
Okay,
didn't
so
think that was reasonable.
Mr. Skirka was a chief.
He was the first assistant.
First assistant, and as chief at the time that he was, before you, I think you reduced him to forfeitures, right?
Right.
When he was chief, before you reduced him to forfeitures, how much money was he making? Do you remember?
Mid-90s.
Okay, he was making mid-90s, and that's about as high as you could make there, right?
Yes.
All right, and then he lost. He said about 40% of his salary. Is that about right?
I don't know. The pay slot for the forfeiture division is at a level that is what it is. I can't change that pay grade. It's
Okay.
the way that the county works. But it was in the 50s, in the $50,000 pay range. But then he had longevity pay because he'd been there for over 4 years, which was a little increase in that.
Okay.
And then
I'm sorry. So why did you reduce him from chief first, DA to whatever, to give him an forfeiture asset job? Why did you?
Well, basically what I wanted to do was change the entire administration. I wanted people who were my first assistant and my chiefs that matched my management style. I'm a very hands-on person. I wanted people who were going to be in there and who were going to help train prosecutors and who were willing to do that and work at all hours and be there at 8 in the morning and stay there until somebody leaves at the end of the evening. And
Sounds like a fun job.
it is a fun job, but
Something like
I
really
changed
great.
that position
Okay.
because I wanted somebody who fit my management style to be my first assistant. And moving Mark to the forfeiture
So you're
division.
saying he didn't meet it? Was he
No.
only working 40 hours a week?
I can't really comment on his employment stuff.
He said he's not going to sue you.
Yeah.
That's what he said.
Anyway,
I'm just kidding. Go ahead.
I basically wanted somebody who would match my management style. And so in speaking with Mark, I knew that he was going to be seeking the Democratic nomination, which was going to mean that he needed to be out of the office to do that. And the forfeiture division isn't something that you have to be in court every single day. So that was going to be a place that would give him the opportunity to use that vacation time to go out and do what he was wanting to do. And so that was an agreement, and we moved him to that division. But the problem is that slot has that pay grade. I couldn't keep him at his salary and move him to a forfeiture
So you're
slot.
saying actually that would give him the time to prepare, and I'm sorry about that microphone. I had the same problem with Mrs. Skirka. The world of public access. I'm sorry.
There you
But
go.
you're saying that would have given Mr. Skirka some sort of preliminary time to prepare to run while he was still working. Is that
That's
what you're
correct.
saying?
That's correct.
And it was an accommodation. Did he agree to it? Was he asked or not?
We talked about moving him. He knew he was going to be moved, but basically I made the decision, and he agreed to it because he accepted it.
Well, then there was another issue regarding, I don't know about what happened when, let's see, Gail Sadowskis was also reduced in her position. She was a chief assistant, some sort of a chief, right?
She was a felony chief.
Chief, and she'd been there for many years. I think Mr. Skirka said he was there for 22 and a half years. And wasn't Gail Sadowskis, I think it's Gail Loeb now, her
Yes.
married name, obviously. She'd been there many years. And what was was there any particular reasoning you care to share why you kind of reduced her position as well?
Well, the thing is that I was a child abuse prosecutor. There were only 2 of us. It is a position that requires a lot of trials, a lot of nuances in the law that somebody very qualified needs to deal with. Gail had that trial experience. Even though as a supervisor she didn't try many cases, she had that trial experience. I needed to be able to move somebody into that unit so that we wouldn't have a lull because those cases don't stop. So I moved her to the child abuse unit, but just like county organization, when you move somebody to a position, they get that pay grade. I don't get to choose to send somebody over with 20% less than what they were making and make it come over here to this pay grade. It doesn't work that way. So I assigned her to the child abuse unit, and she didn't want to do that.
You didn't think
so
there was
she
any other
resigned.
viable candidates who would, within the office? Or, I mean, I don't remember all the office. I don't know. It seems like you like female prosecutors prosecuting those cases.
I do like female prosecutors. There are some men that have expressed an interest in doing it, and sometimes kids are comfortable with that, and sometimes they're not. I wanted it to be a female, and I wanted it to be a female who knew the law.
But isn't it true, I don't know that the new female prosecutor, what's Brittany's last name?
Jensen?
Brittany Jensen, did she have experience, or you didn't have a choice? Maybe you didn't have a choice.
It was twofold. She did have some experience because she did come from the Bexar County District Attorney's Office.
Yes.
And she tried many, many cases there. She tried many cases in misdemeanor court here. She'd been interested in the unit and had watched some of the cases. I think she assisted in some in Bexar County. And so when the position became available, she applied. And that's a position somebody really has to want to do because it's heart-wrenching and it's a lot of work. And
I didn't think it was quite that much work because I thought they had less cases. It seems like they have, and then it seems like they have more resources to spend on a particular case. Is that incorrect?
It's incorrect because what happens is that you've got 4 judges who have you on at least 3 or 4 cases per docket, per trial setting. So you could have probably 10 to 15 cases on a docket, maybe, for a particular Monday. And sure, they go by the local rules, so the one in jail goes first, the oldest goes after that one. But what happens is that these are not your DWI, let me walk in that same day and prepare for trial. These are cases that require a lot of,
I'm just joking.
I know, a lot of defense attorneys do that. They require a lot of preparation because you're dealing with a child, And so it's hard to prepare those cases, and they're cases that take about a week each. And while that week is happening, you still have more cases coming in that you have to review, and you have to get ready for grand jury, and you have to present to grand jury.
What do you present to grand jury? What are you talking about?
When PD or law enforcement agency brings us a case in, we evaluate the case, we prepare an indictment for the case, and then we present the facts to the grand jury. It's a member of 12 people from the community. They serve it 6 months at a time. They listen to the facts that we have, and they decide whether or not there's enough information in those facts to true bill it or to allow us to send it to a court, one of the district courts. So if they true bill it, then that case is assigned to a district court.
And what's the alternative to true billing?
They can no bill it and say there's not even probable cause here to allow
How
this to go forward.
How often does that occur? It doesn't occur very often, does it?
It does occur at least every grand jury. There's something that they no bill.
Okay.
But they sometimes are listening to anywhere from 60 to 100 cases on a Thursday.
So the grand jury is the one who decides whether or not felonies are going to be prosecuted or not in Oasis County?
That's correct.
And the grand jury consists of how many people? 12
people.
And how is it that every time that I am picked to go serve on a jury, it's never a grand jury, it's always I sit in that great big hall and they start asking.
I don't know.
How's that done?
I don't.
Do you know?
They do it by voter stats, but I don't know exactly how they select.
And then the grand jury sits how long?
6 months.
6 months, and then so they meet once. They go there 8 to 5 days a week.
No,
how's that work?
It's just one Thursday, twice a month, because there will be 2 grand juries operating at the same time, and so they'll go twice a month. Unless we have special sessions, sometimes we call them in for a third.
Let's say that I got arrested for aggravated assault, and that I say, look, I'm not guilty. I want to go present my case I want to go testify before the grand jury. Could I do that?
You could go testify before the grand jury.
Do you see it very often here?
There have been a few, not very often. Typically, defense attorneys will tell their clients to keep their mouth shut. The less evidence, the better. At least I did when I was a defense attorney.
Is that what you did?
I did.
Now
you
think it's unethical or something?
Shh.
No, I'm
no,
just
not
kidding.
unethical at all.
What about the firing of? Okay, so Gail Sadowskis left the office because she didn't want to prosecute child cases, and are people protected by the civil servants organization?
We are at-will employees
You're
at the
at-will?
DA's office.
So it's rock and roll. You could be fired for any reason or could quit
no
for
reason.
any reason.
Right.
Okay, so what about the controversy regarding Sandra Eastwood was prosecuting child assault cases or in the child division for many years, correct?
That is correct.
and she got fired. Why was Sandra Eastwood fired from the district attorney's office, a long-term prosecutor?
Because that matter is still pending, I can't
You
get
can't
into.
really comment on that one?
I can't get into the details of
Okay,
that.
and I do think that she mentioned something maybe about possibly filing suit, so it might even be more difficult for you too.
I think the Caller Times printed that. I haven't seen anything like that
Okay,
happen.
you don't have any
but-
objective proof of that, but
Right.
because it's still pending one way or another.
Right.
So, regarding being the district attorney, what are your plans for the future regarding running the office? If, God willing, you win the election and all, you continue. What kind of changes do you think need to be made? Obviously, you think that prosecutors should make more money. Obviously, you think you need more prosecutors. Obviously, you think maybe the forfeiture division could be used better you stated rather, to supplement the prosecutors' pay raises. What other plans do you have?
Well, the plans that I have are things that I have already been implementing, which was to catch up on the backlog. We've done that. I created an intake unit, basically assigned prosecutors who do nothing but intake, and that means anytime a law enforcement agency brings a case in, those prosecutors that are assigned to that unit review the case, make sure the case has everything we need to actually assign it to a court or file it, or whether or not we need to send it back to the law enforcement agency for more information, or decide, you know what, this isn't a case here at all, and dispose of the case that way. So this group in this intake unit has been able to reduce the backlog. Like I said, in about 3 months, they processed 3,500 cases. We have been working very hard. We've also disposed of that many cases in the misdemeanor section too. The felony division also has an intake person. They've worked very, very hard to keep the felony cases going through the grand jury. What I want to see and what my vision is for the office is to have some skilled prosecutors, highly trained, skilled prosecutors to serve this community, to make it a better place to live.
Well,
We've
yes.
not had the training.
Well, but I would say, playing devil's advocate, Mr. Skirka and Sadaskas and Eastwood were some of your better trained prosecutors, weren't they?
But
I mean, or
Skirka
at least
didn't-
longer.
Skirka didn't go to trial hardly ever. Neither did Gail Loeb. Sandra Eastwood went to trial periodically,
Yes.
but there were reasons that led to her termination that I cannot
Okay.
discuss. But what has happened in the DA's office in the past is that from the minute you walk in the door as a junior prosecutor assigned to a misdemeanor court, the training is almost nothing.
Yes, but
And-
is it that way everywhere? It's probably that way everywhere.
I don't know if it is, but it's not okay, because these cases that they're handling have a victim on the other side. Whether it's a theft, whether it's a DWI where somebody wrecked their car, whether it's a graffiti case, whether it's a criminal trespass, or an assault. There's a victim in our community that's not getting an opportunity at justice when somebody doesn't have the skills to present a case to the jury. So I've made an effort to change that. I've made an effort to start the training process in the misdemeanor section. Effective, one-on-one, hands-on training. I have a senior, a felony supervisor who does the training in the felony courts now for prosecutors that never got that training. It's real important to me that we have prosecutors that know how to present a case, so that the victims in the community can have justice.
You're mentioning the victims, and I don't know if you were practicing before all this victims' rights advocacy groups came out, and now, it used to be that you used to deal directly with a prosecutor about a plea bargain in a case. Now there's a whole other element, and to me it's relatively recent, but it may be as long as 15 years ago. I don't even remember. All of a sudden, every time the prosecutor has an additional layer now, they have to contact victims regarding a lot of these plea bargains, maybe most of them.
Victims have rights now. It's in the code.
I see.
And it's important for us to respect those rights. They're members of our community that have had something bad happen to them.
And you don't think the system worked just as well when it's primarily prosecutorial discretion regarding what would occur? I mean, I never saw that. Let me say this. Before they came up with all this stuff, victims' right, I never saw any real abuses. I don't recall them. And one of the issues is too, I don't recall those. Maybe you do.
Well, I think
that
that
might have been
when
before
you're a
your
victim,
time.
When you're a victim, your attitude might be different about those things.
Well,
I don't know.
I'm like everybody
I mean,
else. I've had embezzlements, and graffiti at my house,
Would you want to be
felt
consulted
like-
about the outcome?
I felt like,
Yeah,
you know,
exactly. But you would have wanted to be involved in what happened.
well, I don't know. Really, once you're victimized, it's over. I mean, in a way, it's over. That's why I wonder about the whole process. The criminal does have constitutional rights, et cetera, to fair trial and all this. But I mean, they're not in the Constitution, those rights.
No, they're not.
So that's you can't really comment on Sandra Eastwood's case, but you think that the training for the prosecutors is important because you think it might lead to more justice from the DA's office. Is that right?
That's correct.
Okay. Well, how would you fund that? Well, how long would it be? Would it be classes? Would it be books or continuing legal education? How would you prepare these prosecutors?
Well, a combination of ways. One of them is actually going into the courtroom with them, showing them how to introduce evidence. In the past, the supervisors have been the only ones to be able to go to these advanced training seminars. The line prosecutors typically never got to go. I've already changed that. This next week, we're having several line prosecutors who have tried murder cases and aggravated robbery cases.
Several line?
The prosecutors that work in the courtrooms.
Okay.
We refer to them as line prosecutors.
Oh, that's pretty.
They're going to the
neat
big.
phrase.
They're going to the big training seminar that the chiefs used to be the ones to go to under the previous administration, because they're the ones that are in the courtroom trying those cases. They're the ones that need that information. So training seminars, of course, are really important, but more of it is to actually physically go in with the baby prosecutor or a young prosecutor and say, okay, look, I'm going to do this one time, watch me. I'm going to let you do it, and I'm going to help you the second time, until that prosecutor feels comfortable to do it and knows that, you know what, we're all going to take a beating every once in a while, but they're going to learn from whatever mistake they may have made, and they're going to be able to do it better the next time. That's the kind of training that I want them to have.
One of the questions that I had asked, I was speaking to Grant Jones, a former district attorney, probably before your time, right before the show. He was helping me with something, secret, no. but I was asking him about a pending case of mine and all. And he said one of his biggest concerns, he said, well, ask him about the bail bonds. He said, when I was a district attorney in Nueces County, he said the bail bonds weren't so high. He said now they're 3 times higher than they used to be, and basically inferred that these bonds are now too high and being used as an instrument of oppression. Do you have a policy regarding bail bonds and how high they are? In other words, when a bond is set while a person is in jail pending a pending trial, how that's supposed to be set, or do you have any intake with the judges on it?
What happens is we look at a couple of criteria and we make a recommendation. It's up to the judge to set the bond. We basically look at whether or not this person has a criminal history and whether or not there might be a substantial likelihood that there would be harm to the community to have a low bond and allow this person to get out 3 hours later. And we make a recommendation, but they're typically set either by the JP judges, the magistrates, or the district court judges. Every once in a while, the grand jury will recommend.
Every time I go in and file a motion to lower the bond, every time I file a motion to lower the bond, the prosecutor says, I oppose it.
We typically.
How come? What's the deal on that?
On first-degree felonies, we typically do oppose it. We do oppose
no,
it
yeah,
for the
but
safety
you got
of the
these
community.
criteria, but the truth of the matter, I'm telling you, I'm just joking, teasing you a little bit.
But do your clients have bad criminal histories, or were they bad cases? Because if they were, then they would oppose it.
I'll take the Fifth Amendment
okay.
on that. Let's talk about, obviously, the plea bargains. What is the percentage of cases? Obviously, the high percentage of cases handled in your office are not actually go to jury trial. They are a plea bargain case, correct?
That's correct.
And what is a plea bargain?
Where the defendant makes an agreement for a certain punishment regarding that particular offense. Okay.
And are there any kind of guidelines regarding plea bargains? I know that it seems like the only guidelines I've ever seen pretty much consistent through the years, first time DWI gets probation. Unless there's an accident or something. Second time, it seems like the guidelines are not very, there are some rough guidelines too. Maybe sometimes first time marijuana possession, minimal amount, they might get whatever, deferred adjudication, probation or something. But it doesn't seem like you have much in the way of guidelines. Are you going to change that, or you think it's prosecutorial discretion, it should be up to them, or how is your office working it?
We actually have some guidelines for some offenses. The other, like the misdemeanor cases, we have a supervisor there that works very carefully with the prosecutors on their plea offers. One of the things that we're dealing with now are domestic violence cases and how we're going to deal with those, because we have an influx. In fact, to the extent that we are going to end up having to create a domestic violence unit to try to funnel some of those cases into one area of the DA's office, because there are so many. So there are certain guidelines for certain types of offenses that we do have, but we look at everything on a case-by-case basis. We can't write something in stone and say every single DWI is going to get this, because there are different circumstances to almost every single one of them. So we are teaching discretion, and we are overseeing the offers that are being made now. On 3G or violent offenses, they have to run it by somebody before they offer any type of reduced offense or a lesser included offense. They have to run it by a supervisor before they do something like that.
Let's talk about domestic violence cases, and I'm sure most of the criminal defense attorneys, I get called by a woman every day, and she calls up and says, how much to represent my husband in order to make his bond on a domestic violence case? I go, who's the victim? On an assault, they always say on an assault case. I go, who's the victim? You? Yes. So they're always hiring the attorney, and they're always saying they're bonding them out, and if they can't afford it, and or they're the ones always going to drop the charges. So what's the deal here? To me, there's social or political pressure to prosecute these cases, which are not really prosecutable, or they're spending a lot of money and time on them because these women want to go back with the guys anyway. Isn't it ridiculous? It's ridiculous.
Sometimes they're not willing to protect themselves. And we've seen here in this county many cases where the guy assaults her once and she goes in and drops the charges. And the next time she's dead. And we've seen those cases.
There's not that many of those, but you see where they keep beating them up.
4 is too many. 4 is too many, as far as I'm concerned.
Well, what are you supposed to do? You know, I mean, in this country, listen, I mean, just talking, you know, generally, you know, whatever, I'm Catholic. Do I believe in no-fault divorce? No, but they got it. No-fault 90-day divorce. Divorce. I don't, in other words, I guess we're just speaking conceptually, which isn't necessarily fair to you, because you are in charge of enforcing the laws as they exist. But I mean, it's a little bit ridiculous, and I'm sure that there's some amount of frustration even on the part of prosecutors, isn't there?
There is a large amount. At some point, it would be very easy for the DA's office to say, they don't care if they get beat every other day, then why should we care? But that's not what it's about. It's illegal to beat somebody. It is certainly going to end up in a worse situation if we don't get that person help, anger management, batterer intervention program. If we don't get that victim some power back to learn that it's not okay to be used as a punching bag when somebody had a bad day, then we're not helping our community. And the circle continues. The cycle just goes on and on.
So I guess you're stating that it's a frustrating thing, but it has to be dealt with in the best way.
It has to be done.
What about Mel Gibson? Would you prosecute old Mel?
I don't know. He sounds like he's not okay, truthfully, but I don't know if she's setting him up. I don't know the circumstances.
Well, I said on the internet, I said, you know, the way the tenor of his voice and his maniacal laughter, I said, well, he'd make a great Joker in a new Batman movie. It's just unbelievable, his anger management. And obviously, so you're speaking as a defense attorney. Maybe he's being set up by this kind of questionable woman?
Well, the deal is this. I only want justice, whether that means somebody is innocent or somebody is convicted.
It's not whether or not they're innocent, it's whether or not you could prove the case beyond a reasonable doubt. That's the justice, isn't it?
That is justice. But typically we can prove it beyond a reasonable doubt.
If they're guilty.
Most of the time. Sometimes we just don't have the evidence we need, and it did happen, but we do our best to give the jury everything we have. But I don't want innocent people convicted. I just want justice. That's it.
Well, I think that's what the code states, that the prosecutor has that obligation to, right?
Yes, the code does state something very similar.
You know, at any rate, you were with a sexual assault unit for some sort of years, for a while. What do you think the most important thing is about those cases that the average person may not know?
That victims don't tell right away. That it's really hard for a victim to immediately say, stepdad touched me, or whatever the situation might be. And usually, and often, it takes many, many years before they will actually come out and say that they've been abused. It's a crime of secrecy. It's something that nobody wants to talk about. It's something that's fearful to kids. They don't know how adults are going to react. And so, contrary to popular belief that if somebody hurts a kid, they're going to run and tell, it doesn't really happen that way.
Okay. But it's also true that there's various programs in school, et cetera, encouraging people to come forward now, aren't there?
There are some child abuse prevention programs that do go through the schools, but that doesn't even mean that they'll tell when an adult says it's okay to.
At any rate, on those sort of cases, do you often offer probation?
No. It depends on the circumstance. If it's a touching over the clothes case, there's a big likelihood that they'll get probation. If the victim is not willing or just cannot testify and the family requests us to do that, we will consider probation.
But isn't it true that Grant Jones was stating, the former district attorney was stating, that he considers in many respects, to be sentenced to probation for a child abuse case almost to be a death sentence because of limitations on where you could live, limitations on moving, various classes, length of probation, etc. So the severity of probation on a child abuse case is pretty severe, isn't it?
It is, but what you're really looking at is the amount of contact that a supervision officer is going to have with that offender when they're out on our streets. It's not very much. And the only way we're going to know if they reoffended is if they get caught.
Okay. Is there anything else? We're reaching the end of our show. This has been Anna Jimenez, who's the current district attorney in Oasis County, who is running against Mark Skirka. Is there anything else that you wanted to say that was important I haven't covered?
No, but thank you very much for having me. I appreciate it.
Thank you. Thank you for coming on. It's been Anna Jimenez, district attorney in Oasis County. Thank you, ma'am.
Thank you.
Good night.
You keep saying you got something for me, something you call love, but confess you've been a messin' where you shouldn't have been a messin', and now someone else is getting all your best. These boots are made for walking, and that's just what they'll do. One of these days these boots are gonna walk all over you. Yeah. You keep lying when you ought to be truthin', and you keep losing when you ought to not bet. You keep saying when you ought to be a-changin'. Now what's right is right, but you ain't been right yet. These boots are made for walking, and that's just what they'll do. One of these days these boots are gonna walk all over you. You keep playing where you shouldn't be playing, and you keep thinking that you'll never get burned. Ha! I just found me a brand new box of matches, yeah. And what he knows you ain't had time to learn. These boots are made for walking, and that's just what they'll do. One of these days these boots are gonna walk all over you.